Get your hat.
Where's my hat? Is this my hat? This thing's a little too big for me.
Nobody will know.
Really?
Try to keep
Okay.
doing it, your head will keep swelling.
All right. All right. Order in the court. Okay, well, anyway, you can read this article later on the essence of common law, but it's basically a pro and con. I thought the guy made a pretty good objection and deserved a good answer. All right, let's talk about what a court is. A court is technically defined as the person and the suit of the sovereign. Okay, that's the technical definition that you'll find in the dictionaries, and it's listed under international law. But that's how a court gets started. It's probably easier for you to imagine or to understand what a court is if you just put your mind back to the 16th century when the king or the queen was sitting on the throne and had this court full of courtiers, okay? The people who gravitate to the center of power. So this is what a court is. Now, in modern times, the people, the courtiers, have transformed or morphed into 8.5 by 11 sheets of paper. Okay, so that's what the court record is. The court record is in the memories of the courtiers, which are now sheets of paper. Okay, so when you have trouble understanding what a court is, you can always put your mind back to that setting and you can see it helps you better to understand the process. So it turned out that the king was not all powerful. He actually had limitations which were placed upon him by the nobility, who each of them had their own armies. So the king couldn't really totally take over. And what evolved out of that was the jury system. And to understand what a jury system is really all about is this. Imagine a situation where you have two noblemen who are not happy with each other. Now, their first choice could be to duke it out on the field that's between their two noble kingdoms, you might say, okay? But that's non-productive in certain ways. So what one of them could do is call on 12 other noblemen who would come in with their 12 armies, hand authority over to them, and say, you guys decide who's right here. And so they would decide, and whichever way they decided, it now became 13 armies against one army. So that pretty well made the jury system a respected institution. Who's dumb enough to go up against 13 times his own power? Okay? So the jury system, of course, wasn't totally solid. The king, when the king made an accusation, the king could not be wrong. Okay? And the way that it worked is that if you did have a jury, the jury could decide that the individual was not guilty. But then the jury would have to serve the term. Okay? If the jury is so brazen as to reject the king from prosecuting that individual, that was okay. It's just that they had to go to jail now. And what broke that system was this fellow by the name of William Penn, after whom the state of Pennsylvania is named. When he was in England, he was a preacher in an unofficial church. And the king forbade any of the other unofficial churches to have any meetings. And they put padlocks on the door of the church. Well, William Penn didn't go along with that. What he did is he gathered his congregation right in the middle of the street and conducted the ceremonies there. Well, the king's men came and they arrested him. They had a trial, and it was a jury trial. And it's a rather interesting trial. There's an article in here that reports it more fully. But basically, I think the head of the jury foreman, was a ship owner. But when they were in court, well, first of all, when William Penn started to go into court, the bailiff told him to put his hat on, and when he got in there, he was fined for contempt of court because he had his hat on. Okay? Things weren't much different than they are today. And but when the jury was going in to decide the case, William Penn yelled out to them, "Remember your countrymen." And the foreman yelled back, "Don't worry, we will." Okay, or "Yes, we will," something like that. But they returned a verdict of not guilty. Well, the judge didn't like that. And so the judge ordered the jury to go back in and reconsider. And when they came out, there was no change. So finally the judge ordered them in jail, and they were going to stay there with neither meat nor tobacco, okay, until he got the decision he wanted. Well, that's when habeas corpus came in. And habeas corpus, that was a procedure that existed before, but in this particular case, that got up to the higher court, and the higher court ordered the jury to be released. And that did two things. Number one, it locked in the authority of the jury, and it also locked in the habeas corpus. And so that will be our segue soon into habeas corpus. But William Penn was the guy who was responsible for that. The jury has also, in America, an interesting incident where there was this, in Boston, there was this individual, what was his name? Zanger, I think his name was. Anyway, he was saying very bad things about the mayor of Boston. And it was really screwing up the mayor's political career. And the mayor responded by jailing Zanger and confiscating his printing equipment. And it got to the jury. And he was arrested for criminal libel. Okay? The jury came back and found him not guilty. And the reason is that, you see, there was one point that everybody was in agreement on. And this is what the jury looked at. They all agreed, including the opposition agreed, that everything that Zanger published in his paper was true. Okay? And so therefore the jury said, since it was true, it couldn't be libel. Okay? And that is where that definition got locked in, because the jury suspended the law. It was jury nullification is what it amounted to. And they suspended the law, and they said it's not going to apply in the case where it was the truth. So anyway, that's where juries kind of got their credibility, you might say. Anyway, we go back to a court. Now, I want you to know that when you're conducting your proceedings in court, you need to understand that you have no real physical power. You have legal power, but you don't have physical power. You cannot have a judgment and enforce it yourself. If you do, you will see a big reaction from the government. So you have to keep your guns in your holsters, okay? Unless there's a hot revolution going on, then there's no rules. But as long as we have law and procedure, you need to keep your guns holstered. So you're relying on the sheriff to be the muscle man. That's his real job, actually, is in our modern society. He's the muscle man. You get a judgment, you get a writ of execution based on the judgment, and the writ of execution is the actual instructions telling the juror what to do in order to enforce the judgment. Judgments are not automatically enforced. You have to now execute them. You do it with a writ of execution, and you do that by applying to the clerk. Okay, so what is a court? Well, here's what a court is. A court is a stage upon which the sovereign conducts his show so as to satisfy the rest of the world that his decision is a good one. In my mind, this is the most important court rule of all rules. If people don't respect your decision, it's not going to fly. Okay? I knew a guy, he had a trillion dollar lawsuit, a $1 trillion judgment against the city of Corona. He never collected one penny. Everybody laughed at him. You know, what injury could you possibly have to be worth $1 trillion? It may be worth $1 trillion to you, but who believes you? See? So you have to keep your judgments reasonable. Now, what is reasonable? Well, a good measure of it, only you can decide what's reasonable, actually, but a good measure of it could be the cookbooks that lawyers use. Go to the law library. There are books that do say, well, this injury is worth this much or that much and so forth. And that's just a general rule of thumb. It can be higher or lower depending on circumstances. But you have to appear reasonable to the rest of the world. Also, once you determine what the rest of the world thinks is reasonable, you should always go for a little less. Okay? That way you have credibility in addition to reasonableness. See, if credibility, or I should say power, the power that you're able to exercise through others is very much like money in a bank account. As you can get the interest, true. The minute you touch that capital, you touch the principal, you've lessened your bank account. As long as you don't touch it and you let the interest accumulate, it will grow. So the less you exercise your power in a court, the more respect you will earn. As soon as you start exercising the power, then there will be people who might decide you're being unreasonable. So here's what can happen in the extreme. Let's say you have a judgment against somebody. And so you get your writ of execution, and he goes to the sheriff. The sheriff is supposed to go out and pick up somebody's car. Well, the sheriff doesn't respect your decision, okay? So what does he do? He calls on the phone. He says, hey, Joe, he says, I'm supposed to come out there and confiscate your car. I'll be out there too. Will you be there? Joe says, sure, I'll be there. So the sheriff goes out there, and Joe's not there, okay? And he goes back, he reports back, well, I couldn't find Joe, all right? I mean, we have our legal system, and every corporation, every company, even every household has its systems, its ways of doing things. But for every formal system that you have, there's also an informal system. And what I just showed you was the informal system at work, the behind-the-scenes system. Let me tell you something. You look at the court system, you go into the courts, and you have this staid old judge up there on the bench, you know. Have you ever been behind the scenes after court? I've been in chambers with a judge, and the in-chambers proceeding went into overtime, okay? And I could hear the staff outside. It is so noisy and filthy. The language that I heard was atrocious, absolutely atrocious. Nothing like the image they project when the public is around, okay? pretty bad. So I just let you know that things aren't as they seem sometimes. But anyhow, a court is a stage, and you got to remember that rule. Everything you do, you should ask yourself the question, well, what would an ordinary person who's in a position to enforce your court process, whatever, what would they think of you? Okay, so keep that in mind when you put these things together.
Well,
Yeah.
we call that a reasonable and prudent man.
That, yes, Bob says that is called a reasonable and prudent man. And you're lucky if you can find one. I added that, yeah. But yes, the reasonable man scenario. Yes, go ahead.
But I had a question as far as if you are reasonable and you know, you've gone through all the channels, you have what you have, but the sheriff doesn't.
Yeah, okay, the question is that what if you are reasonable and the sheriff is not reasonable? Okay, he won't enforce it. Well, sometimes you have to fight the sheriff. It used to be that you could make a complaint to the coroner because the coroner seemed to outrank the sheriff. However, they've taken, in a lot of counties, they've combined the sheriff's office with the coroner's office. Okay, so now I guess the governor can do something to suspend the sheriff. I do know this, that the sheriff can be dumped out under California codes by a grand jury. That's all it takes is a grand jury saying you're out of office and they're gone. Okay. However, I've never seen that exercised. I know it was threatened to be exercised a few years back, which is how I learned about it.
I think you can do a writ of mandate to compel the sheriff.
You can do a writ of mandate. Yeah, you can do a writ of mandate to the court to compel the sheriff to do something, or a writ of prohibition if you want him to stop doing something. So yeah. But you're welcome. Let's see. All right. The thing is that, and you need to read this article about the court. It's too long to repeat here, but basically, it's the image that you're trying to develop with the outside world. Now, once you form your court, and it's the person and the suit of the sovereign, okay, the king or the queen is on the throne and is suing somebody for something. And that process of suing somebody is called a criminal proceeding. Okay? There's no difference between a criminal suit and a civil suit and a common law suit, excepting for just some small details. Basically, they're all lawsuits of one party versus another party. So in the criminal proceedings, we require an arraignment as an intermediate process. In civil proceedings, we don't need that. In a common law proceedings, we have other little details. So, but basically, they're all the same. So, when the sovereign sues somebody, he has a choice of what kind of court it's going to be. It could be an admiralty court, it could be an equity court, it could be a common law court, it could be a civil court, it could be a number of things, okay? So, my preference is a court of record, because a court of record has some unique characteristics that I like. Now, the California Constitution says that all the courts are courts of record. I'm talking about the 1879 Constitution. And I love contracting with them and using that one because I like courts of record. What is a court of record? Well, a court of record has to meet 4 requirements. The one labeled number 1 is optional. It generally has a seal. You know, a seal is not a big deal, not for a court. It is a big deal in other things like, you know, real estate paperwork and that type of thing. But when you're talking about a court, it's optional. I went to the federal court one time in Las Vegas, and when I wanted a seal on the paper, the court clerk pulled out a rubber stamp and stamped it, and it had the word seal. That was it, in block letters. See, the only thing you really need for a seal is the word seal. Okay? And you'll notice any seal will have that word in it somewhere, somehow, one way or another. Anyway, the 4 requirements are number 2 through 5 here. It has the power to fine or imprison for contempt, and it keeps a record of the proceedings. It also is proceeding according to the common law, not statutes or codes, and the tribunal is independent of the magistrate. Now, what is a magistrate? A magistrate is anybody on the government payroll who has some authority. Sometimes the governor is referred to as the chief magistrate. But if you look at, in the California codes, if you look at section, I think it's 808 of the penal code, here it is, California Penal Code, okay? The judges of the Superior Court, the judges of the Courts of Appeal, the judges of the Superior Courts, judges of the Municipal Courts, and the judges of the Justice Courts. Since we don't have municipal courts anymore, I'm sure they've changed that provision in 808 now. But those are who are designated as magistrates. So,
Commissioner?
no, well, yeah, he is actually. He is a magistrate, technically, right. But an interesting thing you brought up is a commissioner, a magistrate. Yeah, he's a magistrate, but, you know, we have the Council on Judicial Performance in California. And all of your states have some sort of organization for monitoring the performance of judges. If you have a complaint about a judge, you can complain to that organization. That will not affect your case, okay? But it may affect his career. So in California, you have this Council on Judicial Performance, and they do not have jurisdiction over the commissioners. The one who has jurisdiction over the commissioners is the presiding judge. He has the authority, or whoever the commissioner is assigned to. So if you have a bad decision or bad performance from a commissioner, you have a week or 2 weeks to make your dissatisfaction known to the judge, to the presiding judge, okay? And he has the power to change the decision, okay? If you don't complain, then it becomes locked in concrete, okay? But now, if the presiding judge goes along with the bad decision, he's subject to the Council on Judicial Performance, okay? So when you're making a complaint, first complain to the judge, then if no satisfaction, then complain to the Commissioner on Judicial Performance. And when you complain, anytime you complain, always make it an affidavit, okay? Never write a letter. When you write a letter, it is unsworn testimony and therefore can be ignored. So always make it an affidavit when you write a complaint against a judge or anybody, okay? But, yes?
When there's time, can you explain what the difference is between an affidavit versus a declaration versus a...
Okay, what's the difference between an affidavit and a declaration? An affidavit is a sworn statement made privately. A declaration is made publicly. That's really the technical difference. An affidavit may later become public, okay? But technically, that's the difference between two. For all practical purposes, they are the same. Yes?
Would a declaration serve as sworn testimony?
Yes, yes.
Repeat that.
Can a declaration serve as sworn testimony? And the answer is yes, it is sworn testimony. However, there is a limitation on it. The limitation is this, that when you go to court and when you put the declaration into the record, the person who made the declaration must be there, available for cross-examination. If he is not available for cross-examination, the court can ignore it.
One other thing, a declaration doesn't have to be sworn to. Case law now.
Well, there's a technicality that the there's case law that says that a declaration does not have to be sworn to. However, there is in the California codes, there is a provision that if you make a declaration under penalty of perjury, then that can substitute for a notary. So you do not have to have a notarized statement if you declare under penalty of perjury.
Okay, well, how do you distinguish between, you said not to write a letter because it's unsworn testimony. So how would you, I guess, differentiate between a letter and a declaration?
Well, how do you differentiate between a letter and a declaration? Real easy. The declaration says, I declare under penalty of perjury the foregoing is true and true. That's not in the letter. Okay. See, what you're basically doing is you're going on the line. You're saying, if I'm caught lying, you can put me in jail. Okay? That's what that's all about. Now, the theory is that when you appear before a notary, and the notary says, do you promise to tell the truth, the whole truth, and nothing but the truth, something like that, and you raise your right hand when you do this. What they're saying is, traditionally, is that you have a fear of God, and you would not lie knowing that God is watching you. Okay? That's basically what it is. And that coupled with the fact that you're eye to eye with the notary, face to face. And so it's harder to lie when you're face to face. When you get away from the notary, those things no longer exist. So as a compensation, they added in that, well, you could declare under penalty of perjury that whatever is true. And that's supposed to be the offsetting deal.
As long as you don't sign it without prejudice.
Well, if you sign it without prejudice, it makes it meaningless.
Right.
You know, you can say it, but you retain all rights. You're giving up the right to be free if you get caught lying. So there's nothing wrong with lying in the eyes of the law unless you're under oath. See? That's the trick. So, you know, attorneys lie all the time to the court. You know, if you let them talk. Now, you really need to shut down an attorney when he steps up. When he starts talking, you object. Why do you object? Because he's giving unsworn testimony and he doesn't have personal knowledge anyway. See? So you tell him to sit down. You object it. And what? In any case. I don't care if it's civil or criminal. You know, that attorney starts mouthing off. I object. Why do you object? No personal knowledge and unsworn testimony. He's trying to enter a hearsay. Right.
How would you relate that in an administrative court process?
How would you do that in an administrative court? Same deal. However, in an administrative court, which is in the administrative branch, the executive branch of government, they accept hearsay. Hearsay's okay in there. But when you pull the case over into the judicial side, then hearsay, all of that is thrown out.
So as long as you object in the administrative process, you reserve that you can...
Well, you can object to hearsay, and you should, yes, for the record. But in fact, it's okay in an administrative process.
Yeah, no, I'm seeing that.
Yes, right. Yeah, you see, you're not in a real court when you're in an administrative court. But you cannot go into court until you have finished the administrative process. Now, how do you know when you're at the end of the administrative process?
You're guilty.
That's one way.
We adjourn.
The real way is this. Anytime you are dishonored. Remember, what does administrative process mean? It means the non-court process that goes on. Okay? Well, remember this. You have two parties here. They have their administrative process, and you have your administrative process. So